All right, good afternoon, everybody, and welcome to the September edition of the Miller-Johnson Benefits Lunch Break webinar series. My name is Tripp VanderWal, and I am a member in our Employee Benefits and Executive Compensation Practice Group. I'm assuming that a number of you have attended our previous webinars. In fact, this is actually our 12th webinar. So this marks 1 year that we've started this webinar series. We are going to continue these on at least through the end of the year and possibly into 2022. But on the screen you see here that the dates for the remaining webinar series for the rest of 2021. These are the third Wednesdays of every month. So we're glad you could join us today, and we hope to see you back for the remaining 3 webinars of the calendar year. Again, as always, please let us know if you have any topic ideas that you would like us to discuss. We actually have a lot of stuff going on right now, so we're not really looking for topics. But since we do these once a month, we're always happy to hear what you guys are interested in wanting us to talk about, and we certainly do incorporate those suggestions. Having said that, our next month webinar, I will be back with a colleague from my same group on the retirement side, and we will be going through the end of the calendar year checklist, the things that you should be aware of, both with respect to health and welfare and retirement plans. With that said, for those of you that were with us last month, we started with part 1 of our overview of the No Surprises Act. Specifically, we talked about emergency services. This is part 2 of the No Surprises Act, where we're going to address non-emergency services provided at in-network facilities by out-of-network providers. And again, similar to last month, I have my colleague, Tim Gutwald, joining me. And where last month I really took the lead of the webinar, this month Tim's going to do it, because as you will see, the provisions as they apply to group health plans, when the No Surprises Act protections apply in this setting, the payment provisions for group health plans and other payers are really going to be the same. The big thing here is the notice and comment, which is going to be more of an obligation for providers. With that said, I have a small curveball to throw at you. We are actually going to have, I am live right now, but we are going to switch to a recorded setting. Tim's wife was induced yesterday, and actually we have this weird time-space continuum. So Tim and his wife yesterday had a beautiful baby girl, and both mother and daughter are healthy, so we're very happy for them. But obviously, Tim could not be here to record this webinar yesterday. So we recorded it on Monday, and we're going to play it for you today. Now, having said that, even though you are going to be listening to a recorded webinar from this past Monday, I am going to remain live during this webinar and answer questions throughout the questions on the chat feature throughout the webinar. So if you have questions, feel free to submit those. I will answer those to the extent that I can. If they fall more in Tim's category, we will get a report of those questions. And Tim said he would try to follow up as quickly as possible. With that, thanks again for joining us, and we will see you on the other side. Thanks.
All right, Tripp, thanks for the future introduction. We're going to talk today about kind of part 2 of the No Surprises Act. Last month, Tripp kind of led the discussion on emergency services and how you're going to build that. And we'll kind of do a quick recap here. But this week, we're going to focus on non-emergency services provided at in-network facilities by out-of-network providers. So this is going to be pretty narrow to those situations, but there's a number of considerations. And obviously, you don't get a lot of heads up when that sort of patient is going to walk in and that sort of provider is going to be providing the services. So it's important to know what your obligations and responsibilities are. So what we're going to go over today is we'll do a quick recap of last month's webinar, where we just focus a lot more on the emergency services and a lot on health plan obligations related to that. Then we'll move on to the notice and waiver requirements under the NSA. We'll move to disclosure requirements. And then last, we'll try to give you some practical takeaways on how you're going to deal with the NSA and these notice and waiver and disclosure obligations. All right, quick recap. Again, we talked last month, focused on emergency services. And just as a reminder, these regulations, this law will go into effect January 1st, 2022. So you still have some time to figure this out. But again, we're running out of time. It's going to come up quickly. And as we'll see, there's a fair amount of process. I think that these regulations will require some thinking through, some communications, especially with sort of medical groups, non-employed providers. So I think it'll be important to get out ahead of those things. And last week, we also talked about the prohibition on balance.
Tim, I just want to interject here 1 second. I apologize to interrupt. For the health plan clients on here, I would say the January 1, 2022 effective date, pretty straightforward with respect to the providers out there that are listening to this webinar. But if you're attending, kind of, how is this going to impact my group health plan? As we talked about last month, the effective date is actually the first plan year beginning on or after January 1, 2022. So if your group health plan has a calendar year plan year, it's going to be effective January 1, 2022. But if you, for example, have a July 1, 2022 plan year, these provisions are not going to impact your health plan until July 1 of 2022. And again, I encourage you, if you have questions, to go back to or obviously reach out or review our webinar last month. I think it's a little bit uncertain how that interim period's going to work. Like if a provider of emergency services is subject to these rules on February 1, but the health plan's not until July 1, and they, how, especially the IDR process, like if there's a dispute, the plan can say, no, this is how we pay, using our usual, customary, and reasonable rates. And we're not going to engage in IDR. So it's a little bit uncertain, but just want to point out for group health plans, January 1, 2022 may not be like the drop dead deadline that applies to everybody.
Yeah, and we're calling this part 2. It doesn't mean there won't be a part 3. There's going to be, as I talk about the practical takeaways, like to keep your eyes open, and obviously we'll provide updates about, there's a comment period right now. There's a possibility that there might be some changes to these interim final rules, and there'll also be additional rules and regulations coming out about IDR. And, again, kind of Tripp highlighted this a little bit. A lot of this will be focused on what providers have to do, because they're really the ones that carry the burden when it comes to notice. But the disclosure part does impact health plans in particular. So there's, there is some relevant information for the health plans as well. And it'll be good for health plans to know what provider responsibility is, because if they don't do it right, then your payment obligations change. Mm-hmm. And whether they can balance bill someone is dependent upon whether they meet these notice and disclosure or consent requirements. So another topic we discussed, there's just a strict prohibition on balance billing for emergency services. And we talked about how those, there's appropriate medical screening exam that's performed by hospitals to identify whether a patient has an emergency medical condition. And so, that screening exam is going to be part of those emergency services. Obviously, treatment up to stabilization of the emergency medical condition will also be part of those emergency services.
And possibly stabilization.
And possibly post-stabilization services as well, if there's not notice and consent. That's right.
And again, we're not going to go through that all today, but if you have questions, we go into some pretty gory detail in our August webinar.
Yeah, there's lots of definitions related to both of those terms. So please consult that or give us a call. Again, I mentioned it last webinar, but I've worked a lot with EMTALA, where these definitions come from, and I'm happy to provide some insight into what those terms mean and how they've been applied by courts in the past. So this is more your area of expertise, Tripp.
So since we're kind of going over an overview of last month, again, we don't want to spend a lot of time. You can go watch last month's webinar, but The way that these rules are really going to impact plans from an emergency services perspective is plans which generally calculate participant cost sharing using what is called the recognized amount. And this recognized amount is going to be determined in using these sub bullet points in the order of priority. So you're first going to start with the applicable state all-player model agreement. That's not likely going to apply because I understand that those all-player model agreements only exist, I think it's Vermont and Maryland. And then if we're in Michigan, we're going to move to the next one. Then it's applicable state law. Now, Michigan, as we talked about last week, has a No Surprises Act of its own. Whether that is going to control here depends on whether the plan is subject to that law, the provider is subject to that law, and the service is covered. So if you're a self-funded plan, you're not subject to this Michigan No Surprises Act, so you're going to keep moving on. The last stop is then the lower of the bill charge, or what we refer to as the qualified payment amount, or QPA, which very simply is, it's more nitty gritty than this, but from a very, very high level is generally the median in-network rate that's recognized the plan for the items or services involved in the emergency services. Next item is, once you determine this recognized amount, this participant cost sharing must apply to a participant's in-network deductible and out-of-pocket maximum, in-network deductible and in-network out-of-pocket maximum requirements. Next slide, please. Moving on, so once you've determined the participant cost sharing, then we're going to determine how we pay these claims. So what is required is that the plan make an initial payment within 30 days upon the receipt of a clean claim, which basically includes all the information necessary to process the claim. And I apologize, I missed this in our webinar last month. These 450 pages of regs that I'm still kind of working through. The regs do clarify that this initial payment is not supposed to be like an installment payment or a down payment or a deposit. It's really supposed to be what the plan reasonably intends as the payment in full for the item or service. And then, to the extent what the total payment from the plan, and obviously this is going to factor in whatever the participant cost sharing rate is again going to be determined in order of priority. Applicable state all payment model, again, not likely to apply. Applicable state law may apply to some fully insured plans. An amount agreed to by the plan and provider, I think we'll start, even if we don't have more out-of-network providers move in-network, I still think we're going to see these kind of informal agreements as we go on. I'm a plan or a TPA of a plan, and I know what the provider is going to accept in these. And then the last stop here is if we can't agree, we move to this independent dispute resolution, IDR. And the feds have promised more guidance on this IDR process in the future, probably not coming yet in 2021. I'd be shocked. When it does, we will likely have another webinar to discuss.
I thought I saw somewhere when I was getting ready for this that they were shooting for December. But...
Oh, okay. Then I take that back. I know that a lot of the other, this again, No Surprises Act is part of this Consolidated Appropriations Act of 2021 that was signed last December. Contains a lot of provisions that are going to impact group health plans. And the Department of Labor has basically, and we'll address some of those in different webinars. Department of Labor has basically said, we're not going to get out regs before the effective date of a lot of these laws. So it delayed some, but others that it didn't delay, it basically said, so you just need to, comply with these laws using a reasonable good faith interpretation of the statute. So good luck. You're on your own for a time being. Anyway, next slide, please, Tim. I think going back to you.
I will say, Biden's new vaccine requirement is going to require some new regulations from CMS and HHS. So that might push.
And I think even DOL, right?
Yeah.
So and a lot of these regulations are going to come from DOL, HHS, and IRS in this situation. So I think the regulatory agencies are pretty taxed trying to get guidance on a timely basis.
I would be surprised if they met December under regular circumstances. So I'd be shocked if it's not well into 2022 that we see some of these regulations. All right. So,
and Tim, this notice and comment, this is really the meat of, this is the main this is the main act of today's webinar, right? This notice and comment.
Right, and right. This
Or
is
notice and consent. I
this
can
is
say
really-
notice and comment.
notice and waiver, or notice and consent. Either way you want to look at it. So it's a waiver of the protections or consenting to waive the protections of the Surprise Billing Act. So yeah, I mean, this is really the meat of it for providers. When it comes to the emergency medical treatment, if you're the provider, like you just get what you're entitled to under what the plan's required to pay you under the act. And there's not really much more you are required to do, except for, as we kind of alluded to before. So really there's two situations where a patient may knowingly and voluntarily waive the protections under the SBA. The first we addressed last month with the post-stabilization services. So again, a patient comes in
an emergency setting.
So this is, they come in, there's the medical exam, they determine the patient has an emergency medical condition, if they're treated, and then now they're stabilized. So they can be admitted or transferred or whatever the appropriate thing is, but they are stabilized. So they've been stabilized, the patient is competent, the patient has been provided notice, and the patient consents. And again, we talked about some of the specifics, but you have to take into like cultural awareness. You have to take into, where the ability to transfer. It's very complex.
Reasonable distance, which can be impacted by other factors. Does the participant have access to their own transportation? Or do they have to take public transportation? If public transportation, does that narrow what a reasonable distance is? So it's pretty, I think it'll be complicated.
Well, and I remember, when I was preparing for this and looking back, like, how would a health plan know what was, whether it was reasonable to transfer them in those situations? So,
and to layer on top, I think it looks like the patient can always say, no, I don't want to be transferred, and then these post-stabilization services are going to be subject to this non-balance billing.
Yeah, I mean, I think sort of my takeaway from the post-stabilization aspect is it seems unlikely to me that we're going to see a lot of situations where a patient is stabilized and then a provider is able to go through this whole process and gets the consent, provides the notice, and the patient can be balance billed for those stabilization services. I think where we're more likely to see this is for services provided at an in-network facility by an out-of-network provider. And again, so facilities, as we discussed last week, includes ASCs, hospitals, standalone EDs. It does not include urgent care centers in Michigan because they're not licensed in Michigan. So, and one thing I did notice in the regulations, and I know this, I have clients who are doing this for the state notice requirements. And remember, there's a state notice requirement for providers that are listening in, that it's not the same form that the feds gave us. And so you're going to need to get two different forms of notice consented to by patients. But
why wouldn't you?
Right. I'm sure patients will love it too.
Yeah.
So the notice can be provided by the in-network facility. So, a lot providers are not always there. They're not the ones that have the initial contact with the patient. They may not be scheduling the surgery out in advance. And so that's where they can work with in-network facilities to do that. But I think, and I get this to the practical takeaways, I think what's going to happen is, providers, independent providers and hospitals are going to sit down and be like, okay, here's where we're in network, and try to line up, if not 100% of the time, which is often the case, very, very close to 100% of the time, because this just becomes very difficult to deal with. So patients, they may not waive protections for any of the following. So we'll get here in a second about how they can waive them and the notice that needs to be given to them. But before we get there, I want to emphasize that there are a number of situations where they're not permitted to waive protection. So emergency services, which is again what we discussed last month, air ambulance services, which is not something we're focusing on really here, but again, they're really treated understandably like emergency services, so they can't waive the protections for that. We also have items, services provided by non-participating provider when there is not. It should be when there is a participating provider available. So, if a hospital has in-house, in-network physicians, let's say, that are employed by the hospital, and for whatever reason, an out-of-network provider is there and currently providing services, to the patient, then in that situation, a waiver, a notice, getting them to sign the notice and consent doesn't do you any good.
Can I ask a question? So items are say you cannot waive your protections for items and services provided by a participating provider where there's not I think that's written correctly, isn't it? Because if there's not a participating provider available,
Oh, you're right. Yeah,
you can't waive it.
That's
if there
right.
is a participating provider, you can say, because you can't waive your protections if there's no participating provider that can come in and do what the non-participating provider can do.
You're right. You're right, Tripp. I appreciate the correction. So that's correct. If the patient doesn't have a choice, then they can't waive. Right? They can't be sort of extorted into waiving their protections under the NSA. Items and services for unforeseen urgent medical needs. And again, the logic is the same as what we just discussed. They don't have a choice as to needing these things, and so they're not going to be able to waive their protections for those kind of either items or services.
And I think the next one's the big one.
Yeah, the next one is the big one and really impacts a number of clients that I've worked with who are worked up by the state law, and this one really treats them even worse. Ancillary services that the patient does not typically select. So again, if I go show up at the hospital, I don't get to select my emergency service provider. If they're contracted, they're out of network for some reason, then, or an anesthesiologist for a procedure. Again, the situation where I most commonly would think about this is like an ambulatory surgery center. You're receiving like a colonoscopy, and you might not have any idea who the anesthesiologist is. And so since you didn't get a chance to select them, they can't balance bill you.
So, I mean, what this boils down to is these providers of ancillary services are just not going to be permitted to balance bill after this year.
Right.
Does that mean correct?
That's right.
I mean, if you're nuts to bolts, that's what this means.
That's right. And same with diagnostic, right? If I get my blood drawn while I'm in the hospital, I have no idea who is going to run that test or who's going to look at that x-ray. So again, that's another, they're not going to be able to balance bill anymore. And then items and services provided by other specialty practitioners as may be specified in future guidance. So again, I mean, I think it's really important to keep in mind the intent of the NSA. We kind of talked about this at the beginning of last month's seminar. It's clear that legislators saw it as unfair that patients would have no idea that they're signing up for a giant bill and then end up with a giant bill. And so they're not going to let that happen any longer. It's only really going to be, and we'll get into the notice requirements here in a second, it's only going to be when a patient very clearly elects to take that risk upon themselves and is choosing the provider for a very specific reason that you're going to be allowed to balance bill at this point.
Mm-hmm.
All right, so out-of-network providers must provide very specific notice and consent requirements. And I've seen, I've seen some publications about this that said you must use the model notice. And I initially had that on here, Tripp, and you're like, I'm not sure that's right. And so then I had to find my way through 411 pages.
Well, and the reason I call them is because, again, for those folks that have listened to a lot of my webinars where we've talked about model notices, on the group health plan side, model notice is just that. It's a model notice. You don't have to use it. We typically recommend it. Now, maybe we want to tweak some things to make it, more appropriate to your plan. But the advantage of using a model notice, again, it's not required, but the departments will usually deem your notice to be compliant with the law if you use the model notice. Think COBRA notices is a good example. So when I saw must use model notice, I was just like, to me, that doesn't sound right, but so I pushed back on Tim.
Yeah, what was that? ACA 1557, where you had to provide the notice in all sorts of languages.
Yes.
That was another one where you weren't required to, but why would you change anything in the model notice?
I remember trying to copy and paste all these different languages for some clients, and sometimes it just wouldn't show up, especially with the languages that are more character driven, if you will. So it's glad those things are gone. But,
yeah. And so we strongly recommend providers just use the model notice. It's available on CMS's website. It's a zip file, so you download it and then you'll be able to access what the model notice is. You will have to add some additional information. So the only modification permitted are to identify the provider, the provider twice apparently, the specific items and services that are being provided. You're also, obviously, another thing that's going to need to be added are good faith estimates of charges. So that's going to be an important component of this. And again, that goes to the intent of the NSA to make sure patients know what they're getting into. This was interesting, and not how the Michigan law treats their notices, that there's a very specific provision that says it must be its own form. It cannot be part of admission form. So it has to be, you can't just tack it on or shove it in like a deck of cards with all those other documents that I'm about to sign tomorrow morning when my wife is admitted to the hospital.
Just one more document, just fill out your name and address and number and sign at the bottom of it.
But this one will have to be separate from those other forms. And it must be provided 72 hours prior to the appointment, or 3 hours if that appointment is the same day. You know, sometimes, you know, relatively rare that you'll make it, you know, some patient will come in and they'll have an appointment the same day, but it has to be 3 hours in advance.
Well, I guess another way to look at that is maybe 72 hours before a scheduled service. Like if you're, you know, if you have a surgery that's scheduled, you know, a couple weeks in advance, it's got to be provided 72. But if you're more in like I wouldn't, again, not an emergency basis, but you've gone, your doctor said, hey, you know, did a heart cath and said, we got some blockage in there. We need to get in, you know, and do a bypass relatively quickly. Let's schedule it for tomorrow or the next day. Then you're within the 72 hours. So it's got to be at least provided 3 hours, correct?
Right, that's right. And so one of the things I know providers here in Michigan with respect to the Michigan law, they've mailed these notices and asked patients to sign it so that you can say, hey, I provided it 72 hours in advance, even if it's not signed that far in advance. It's not, I don't know exactly how all that's going to play out. It seems like a pretty reasonable approach to me.
So that goes like in the initial packet, like here's what to expect on your day of surgery type stuff. Okay.
Right, exactly. And so, you know, again, this is where I talked at the outset about how it'll be important for some of these ancillary providers to work with the hospitals or health systems to try and do this. Although, again, you know, if you're, some of these providers are just stuck.
Yeah, ancillary providers, maybe not the best example since they can't avail themselves of this exception to the Surprise Act billing protections using this notice.
I mean, frankly, it's difficult for me to conceive, and this is what I do. I'm very familiar with health system, our healthcare system, and it's tough for me to come up with the perfect provider that could somehow take advantage of these notices. It seems to me that maybe like an oncology specialist who, you know, the patient, but I don't know why the patient would be in network with the facility in that situation. It's difficult, like I said, to come up with a scenario where this is all very helpful. But again, I mean, you see these timelines, and that's why it's going to be important for if hospitals especially are going to make any effort, or providers are going to make any effort to try and get these notices and not just be like, I'm just going to take, you know, what I get paid from the insurer. Then, you know, you really have to think about this. And, you know, when patients come in for a physical in advance of a surgery to get these documents in front of them at that time, or when they're work with your outpatient providers who are, you know, your orthopedic who's going to be scheduling the surgery, get them to meet and make sure they're signing. It's just going to be difficult to
probably something like I mean, again, if you can avail yourself of this notice and comment, I mean, if you have any type of pre-consultation, probably something to do, take care of then, right?
Right. Yeah, I mean, you almost need like staff for like a non-bill, have the patients come in where it's not going to be, you're not providing any medical services, just as you move up when you used to do that orientation or admission kind of process for surgery. But again, that's why people need to start thinking about this now, changing the processes and procedures so that they might be able to meet these requirements. And again, an incomplete document is treated as a lack of consent. And this is where, you know, this is helpful for health plans to know that what the requirements are, because you can dispute if a consent shows up along with it. And I'm not exactly sure how, does this get submitted with the claim? It must. Most claims are electronic nowadays. And so
I think the harder one is how are you going to dispute necessarily if you're a plan? You know, I mean, I can dispute the incomplete document. If I'm looking at the document, it's like, it's incomplete. But did you provide it within the appropriate time frame? And then how do you establish that?
Yeah, I mean, if it's not timed or dated, do you just reject it out of hand? And then So again, we'll see how it all
We'll
plays
touch
out.
on that again in a few slides. I know I'm really interested in this next one. The notes we're back to this 1557. Notice of consent must be provided in the top 15. So that means if I go get a procedure, if I get one, in 2022, I'm gonna get a notice. I took a little bit of high school and college Spanish. Don't remember really anything about it. So English is really the only language I know. Am I going to get 15 notices in all different or do you just have to maintain?
Yeah, I mean, I think it's going to look like what we did with the 1557. It's going to be, right, so the model notice is pretty short. It's just kind of one pager. And so it's just going to be, all
Repeated.
of that crammed over and over again, I think, with the number. I mean, and again, this, it seems sort of absurd, but it makes sense since it doesn't do a lot of good if a patient can't read what that number is telling them. I mean, obviously that good faith number is the key importance, but as we said, with the post-stabilization consent process, I mean, the clear message was, you better make sure that people really understand, and you're not going to be able to trick people or be coy or kind of hide the ball when it comes to this. People have to know what they're agreeing to. All right, so disclosure requirements and complaint process. Providers and facilities must publish surprise billing protections on their public websites. Does not apply to air ambulance providers. Disclosures must explain the requirements and prohibitions and state law requirements as well, which that was an interesting aspect to me, because the federal notice, obviously, the feds provide you some, you can just post it on your website. That's everything you need to know there. But now you're also required to sort of describe and explain the state law requirements, which if anybody has listened in on our webinars and knows it's not perfectly clear. Mm-hmm. So that's an area where I think, we might be able to help health plans and providers by coming up with a nice summary for them that we think will meet these requirements.
For the Michigan No Surprises Law or No Surprise Act, I forget exactly what it's called. There's a notice requirement in there, right? Or at least a notice. But unlike the federal agencies, the state of Michigan has not provided a model notice, correct?
Correct. There's some language in the statute itself that you can sort of copy and paste. But it says, here, explain the requirements and prohibitions, and that language doesn't really, certainly, I don't recall it explaining the prohibitions. So, I think there will need to be a little bit of work here for clients to do, whether, again, a provider or a health plan, and we'll kind of get into what health plans have to do. Include contact information for reporting violations. We don't have that yet. The regulations, the interim final rule simply said, we're going to come up with something and leading to that. So the complaint process, they're going to establish a single system for intake of complaints. There's going to be no time limit for filing a complaint. There's a whole little blurb in there about how they considered a 90 days or 60 days, but ultimately they decided that it's just important for people to be able to file these complaints, and then the agency is going to have 60 days to respond to the complaint.
Now, it'll be interesting. The 60 days is a pretty tight turnaround, especially with how much is going on. But if they're anything like the IRS, what comes within 60 days is, we've received your complaint. We need additional time to review your complaint. Please stand by.
Yeah.
And then that kind of opens up for as much time as they need.
Yeah. I mean, I think I had a HIPAA breach that lasted 3 years before the thing was completely closed. So, I'll be shocked if there's any meaningful and substantive response within 60 days to patients.
Now, having said that, like with EBSA, which is the Employee Benefit Security Administration, which is the sub-agency of the Department of Labor that governs ERISA benefit plans, I've noticed even in the COBRA subsidy type stuff under ARPA, if it's a participant complaint, they're usually on that much faster than they are, some of the other stuff. I mean, because we've had a couple clients who are trying to figure out this ARPA COBRA subsidy notice stuff. And, one in a very weird situation, the ball got dropped, and it turned out that the individual was eligible for the subsidy. So they called EBSA, and my client got a call very, very quickly after that from a Department of Labor agent. So maybe they'll be able to get it done. We have a lot. There's a lot to see, to always wait and see here.
For sure. I mean, patients are going to know if they get a big old bill, I don't think they're going to hesitate to call that complaint line for sure. So here, the group health plan requirements also have disclosure obligations as well.
Yeah, so, if and I kind of snuck this in there, the disclosure requirements are on the next slide. I apologize. This may have been a better slide for key takeaways. I apologize. But if the NSA protections apply, and really that's going to be any time that the notice and consent requirements were not satisfied, either you chose not to do them, you didn't do them right, or you're a provider of ancillary services. Really, from a group health plan perspective, you're going to have to process the claim from the non-participating provider using the same method that you do for emergency services. So again, go back and listen to last month's webinar. That's the process that you're going to have to follow. For non-participating providers who are not eligible for the notice. So I guess the question is, Tim, is how is a group health plan going to know if these notice and consent procedures are required? So, my first bullet for ancillary services, you get a bill from an anesthesiologist, or a pathologist, they're not eligible, so we know the NSA protections are going to apply, and you're going to have to process the claim the same as you would emergency services. But for the other ones, how do you know? I mean, maybe you take, again, this is kind of me just thinking out loud here, maybe you just kind of assume that the NSA protections will apply unless the provider indicates and or provides a copy of the notice and consent that they've received. And then when you get that, you process, if the NSA protections don't apply, you process it like you would any out-of-network claim that you're paying right now. You pay the UCR rate. And I guess that'll be interesting too. If a out-of-network provider determines that the rates that they're getting through the, after maybe they go through either agreement or IDR process, or however we figure out this out-of-network rate, if they find that it's greater than what they're currently getting paid under the UCR amounts, maybe the notice of consent they're voluntarily forgo those.
Well, I do wonder that, because it's not like, they're going to get this payment. It'll be treated like emergency services. So it's not like they get no payment, or that the health plan just gets to decide, some other amount. So I do wonder if is it really worth it? If you're a hospital, are you gonna bother helping an out-of-network provider provide these notes? I just don't. Frankly, it seems unlikely to me. And honestly, I haven't gotten a ton of calls about clients asking help to navigate these notice requirements. Again, some of my clients are clearly just no longer allowed to balance bill people, but and the hospital clients, they have big legal groups. Maybe they're figuring it out on their own, but I do wonder if that's just going to be the practical impact of this.
You can go to the next slide then for it. And then, so again, we touched on this last month, but is there a disclosure requirement for health plans? So group health plans have to, provide this disclosure on the plan's website, not the plan sponsor's website. And I think in reality, what that means is most plans don't maintain a website, outside of maybe multi-employer, Taft-Hartley union plans that are separately administered. They have a plan website. So the notice is going to have to go up there, but your garden variety employer sponsored plan doesn't have its own dedicated website. And you're not required to put this on your organization's website, right? That if you sponsor a plan. So I guess the question is outside, this notice also has to go on explanation of benefits. So outside of the EOB, when do you provide this notice? I think, again, there's a lot of uncertainty. Maybe you put it in the plan, with all the other notices in the plan, annual open enrollment materials, maybe you put it in the SPD, maybe you do both. I think that's a conservative approach. Maybe we'll get some DOL FAQs on that. We'll see. But disclosure has to be in plain language. It has to include, information about the restrictions on balance billing in certain circumstances, the applicable state law protections. So, and again, in Michigan, that we're going to have to model. There's a model notice, as you can see on the slide. We're going to have to modify it to explain, at least in some level of detail. I don't think it has to be too detailed, but right. We have to basically tell there's a Michigan law out there, and here's what it is. The requirements under the Federal Non-Surprise Act, that's going to be covered in the model notice. And then again, information on contacting state and federal agencies if the patient wants to file a complaint because they believe these No Surprise Act rules were violated.
Well, I'm just thinking this now, not to put you on the spot, but if you're in a ERISA plan in Michigan, the Michigan law doesn't apply, right?
Yeah, you're right. So I would say that's a great point, Tim. Thank you very much. So if you're a fully insured plan and you're going to use this model notice, but then is it the insurance company that's preparing the notice, and maybe you as the employer? So then it's probably going to go in your certificate of coverage that you're getting from the carrier. So and so I mean, you're still gonna, if you're self-funded plan, you're still gonna have to provide this model notice. But you're right, maybe we can delete those provisions about the Michigan No Surprises Act.
Yeah, as we said, you can use the model notice to meet this requirement. So I did want to talk about, because again, these two, there's last year, there was a hospital transparency rule that was passed and went into effect at the beginning of this year, applies to all licensed hospitals. And what this did was require hospitals to list their charges, just very, very high level provided here. There's been a lot of controversy on this. There's been a lot of allegations that hospitals aren't doing this. And I have seen some claims, although I haven't heard of.
There's been litigation of this.
Yeah.
Is it ultimately been?
Yeah, it's been upheld. Yeah. Okay. Legal challenges have failed. Okay. So I think that's part of the reason why we haven't seen any enforcement. But I suspect we'll start seeing some enforcement on this now that all the legal challenges.
And those folks out there that are attending this for health plans, coming soon to a theater near you, these transparency requirements. They were going to be effective already of 2022. They have been delayed. They actually are funneling through two different mechanisms. The departments had previously issued regulations requiring these cost comparison tools.
Yeah.
And they weren't going to be effective until January 1, 2023 for the top 500 item and services, 2024 for all items and services. Consolidated Appropriations Act kicks in, basically does mirrored requirements. I think they added a telephone requirement. You got to do these comparison tools through telephone as well, but we're going to kick in effective January 1, 2022. Departments of Labor have delayed that date. And they are actually they're not rescinding the previous regulations, but I think they're going to re-propose some regulations to try to merge these, their previous requirements through regulatory action and this Consolidated Appropriations Act into one. So you don't have to do kind of a compliant comparison tool for under both requirements.
So I brought this up for two. One, to kind of remind people that this is out there, and two, because there's this good faith estimate requirement within the No Surprises Act. That's what has to be listed on the notice. And so, the impetus for the NSA was these sticker shocks of these giant crazy bills that people would get from out-of-network providers. And, if we have this additional transparency that you're talking about from the plan side and this side from the hospital, is it a good faith estimate to list something that's $10,000 more, $20,000 more than you're seeing at any other hospital or that any health plan is paying? So, and the other reason I wanted to point that, so that'll be interesting to see if that sort of information, that price transparency, is used against out-of-network providers seeking to balance bill. But the other is, again, just to emphasize it, the emphasis here was so patients and beneficiaries know what they're getting into when they show up, so that there aren't surprises anymore, so that they know what they're ultimately going to pay and they're better educated. So, again, that just kind of emphasizes that, the horror stories are going to be heavily scrutinized. If you're ever balance billing a patient, you better make sure, all your I's are dotted and all your T's are crossed. All right, so some practical takeaways. One, look out for more rulemaking. We talked about that. There might be changes to the final rule. There's going to be dispute resolution process. We'll probably learn some more about the complaint process as well. So look for additional information on that. Again, prepare the model notice and consent forms. You're going to need to include a summary of state law. Maybe not if you're a self-insured plan, because that wouldn't impact you. Again, and you'll have to update that. So if you do that now, we still don't know what number or what address complaints are supposed to be sent to, or what website they might be filing them. So, you're going to have to update that by the end of the year. Physician groups and facilities, should really sit down, cross-reference participation status, identify if there are any plans that especially the hospital or health system is in network on and the provider is out of network. and determine how you're going to provide, if, who will provide the notice and how you're going to provide notice, physician groups, again, if you're out of network, consider, entering in negotiations for, to maybe with those payers so that you can narrow down the times that this will happen, that you'll be required to do the notice, or again, maybe you just won't care. Maybe it's a small enough percentage, and you are settling a lot of those anyways, and you're not going to bother taking patients to collection anymore. So maybe you're just not going to bother at all. Again, this is kind of a little bit duplicate. Prepare the sample notice and establish a process for providing it to patients. Update your website if you're a provider, or work with, if you're an employee, if you're a health plan, if you offer health plans, work with the insurer, figure out where information is going to be posted. Again, the big impact on certain types of providers. Notice and consent, will be impossible for certain providers in some situations. Well, again, these ancillary providers, anesthesiologists, radiologists, emergency medicine are going to be completely prohibited. In other situations, are you going to be able to meet that 72-hour requirement if you don't see the patient beforehand? Or if you're an out-of-network and you're an exclusive, and you're the exclusive provider of services, like say you're a hospitalist group and there's no in-network group, and you have an exclusive contract with the hospital.
And that's not that uncommon.
No, that's not uncommon at all. Exclusive agreements are not uncommon at all. Again, this only applies if the hospital is in network and for some reason the provider isn't. But if that's the case, again, you're not going to be able to balance bill in those situations. Payers may use the NSA to negotiate lower rates. I heard from some clients when the Michigan law came out, what happened was payers were like, we're booting you out of network. And so now you as a provider have a choice. You either jump through these hoops to provide notice and then you can balance bill patients, or you take our new lower rate that we're going to offer you, because if you don't meet the notice requirements under Michigan law was what, like 120% of Medicare. And under this law, it's going to
be more plan specific.
Right. It'll be more plan specific. It'll be better than what Michigan law provided. So again, there might be negotiation of lower rates by some insurers. The good news, especially for patients and, potentially for plans, I think, there's more transparency. Your beneficiaries, if you're a plan, are less likely to get some giant bill from an out-of-network physician now. From employers' perspective, that's not great if an employee is suddenly bankrupted or in considerable financial stress as a result of some medical care because they were out of state or whatever, or by some fluke of contracting, they were treated by an out-of-network provider. More clarity for disputes involving out-of-network patients, providers, and facilities. Well, we'll see the dispute resolution process. Hopefully it won't be too complicated. And it should also motivate recalcitrant OON providers to move in network. Then they don't have to worry about all this stuff that we just talked about today if they just get in network with all of their kind of local health facilities.
Which I think, but kind of goes to your point you made a couple of seconds ago. It kind of takes a little bit of the provider's leverage away in negotiating that, because the leverage on the plan side, or on the plan side or the payer side, is you can get rid of all of this hassle if you just come on network. But here's what we're going to pay you.
Right. Because if you're out of network, even if you jump through all these hoops, you get this lower rate. Or if you don't bother to jump through the hoops, then you get this lower rate.
I think, frankly, before we can decide from a plan this is obviously going to benefit patients. I think there's no question. But from a plan or provider, how much this is going to impact, who's going to be, if you look at plans and providers on the opposite side of the, in competition with each other, who's going to be the winner under these laws? I think we're just going to have to wait and see.
Yeah. I do have to say that when the Michigan law came out, I had a lot of clients call, and really out-of-network bills are not a very large percentage of what they did. They're in network for 98% of the patients that they're treating. So again, this is not some huge portion. of it. It's just kind of interesting that this is how legislation often works. You hear these small, it's a horror stories from very small percentage of people that lead to these like giant bills.
And it's interesting anecdotally when the federal law came out, or I heard that both payers thought the advantage went to the plan, or the payers thought the advantage went to the providers. Providers thought the advantage went to the payers. It kind of reminds me of this old Law and Order episode where Jack McCoy is arguing a motion in judges' chambers, and the judge makes a decision, and both lawyers are ticked off with the judge's decision. He goes, "Well, if you're both upset, then I know I get it right."
I do hear a lot fewer complaints from my provider clients, about this bill than I did the state law bill. I think the biggest thing is the payments for the services they're higher. And they're a little bit more clear, I think, as well. So, we'll see. It'll be interesting to see how all of this plays out. Whenever I think something is not going to be a big deal, I'm often proven wrong. So that ends it. And maybe the reason you guys are listening to me record this is because my wife is going to have a baby tomorrow.
Which, when you hear this, was yesterday?
Yeah.
It's this weird time space.
That's right. My wife had a baby yesterday, Tuesday. So maybe we'll try to add, if we can pull it off, a picture of the little baby, of the little girl that we're going to have. So thank you guys for your time. And Tripp and I are, we might be back for part 3. If not, we're happy to answer any questions.
And let us know if you have any questions, or we couldn't get any in, and I'll, any questions that I couldn't answer, and I'll try to get those over to Tim. And thanks again for joining us. Please join us in October. Just to give you a heads up at what the topic is, I believe that I'm going to be joined by one of my retirement plan colleagues, and we are going to be discussing end of the year kind of to-dos for both health and welfare plans and retirement plans. So again, that'll be the third Wednesday in October, and the topic is both on health and welfare and retirement, kind of the checklist of things you need to do and be aware of now that we're approaching the end of the year. Thanks, and have a good month.